Thank you so much, members of the committee. Thank you so much for the opportunity to testify in support of 7226, which is incredibly important, and I think Anna and Sarah spoke so eloquently of the dire need for this law. I've submitted written testimony that's much longer, so I'm going to just hit the highlights. And I want to acknowledge that there actually is also in the room today a commissioner from the Uniform Law Commission who represented Rhode Island, which I think will be of great help to the committee as well. So my name is Crozier. I'm a senior staff attorney at GLAD, GLBTQ Legal Advocates and Defenders. We're a New England-based organization dedicated to ending discrimination on the basis of sexual orientation, gender identity, and expression in HIV status. I have a particular passion for respecting and securing the rights of children born to LGBTQ families. In Rhode Island, we have collaborated on important family law cases before the courts, Rubens versus DeCenzo, which was the case that established de facto parentage in Rhode Island. And outside the courtroom, we work in collaboration on legislation like this. My colleague, Mary Bonato, was instrumental in the Maine Parentage Act, which is very similar to this act, and I serve on the Uniform Parentage Act and National Enactment Committee, and am working on efforts in Massachusetts and Rhode Island as well. So I think this legislation is in good company and critically important for Rhode Island. And Rhode Island really has been a leader in LGBTQ equality. You were the first state to have protections on the basis of gender identity and expression. You were a leader in the Rubens case in protecting children born to de facto parents, and recently became one of the early states to ban conversion therapy. So thank you for that. I think despite this leadership, Sarah and Anna said it so well, the pace of modern families, the pace of societal change has really outpaced Rhode Island's parentage laws. Many more children now are born through assisted reproduction, and 40% of children nationwide are born to unmarried parents. So this is really critical to address. There are substantial holes in the current statutes, and these holes really create vulnerability for children. There is no, as Sarah and as they spoke about, there's no availability for unmarried same-sex couples to sign a voluntary acknowledgment of parentage form, and that is a critically important way outside the court system through consent to establish parentage by agreement that different sex couples can now do. There are no statutes addressing assisted reproduction. There are no statutes addressing gestational carriers. And what do these holes mean in the life of the child? Really potentially disastrous consequences. Before I came to GLAD, I was a family lawyer, and I saw firsthand families and children who were really harmed by the lack of statutory language. In one of my cases, a client of a child who was born in Rhode Island, because the child was born in Rhode Island, my client was not on the birth certificate as a non-biological mother. And the birth mother took the child to visit a grandparent in another state and cut off all contact, and we spent 4 years in court trying to get her back. We were successful, but statutes like this would really make it clear who has access to parentage and who can establish parentage rather than having to litigate that through the courts. So in my mind, this bill is very clear that it really promotes the well-being of all children in Rhode Island. It recognizes the great diversity of families in the state, and it brings clarity of who has access to the courts, who can establish themselves as parents. It doesn't do anything to change the court's purview over child support, custody, visitation. That remains in the court's discretion, but it really just says who can be a parent and who is a parent. This bill particularly is important for LGBTQ families because, again, it says that parentage law is gender neutral and marital status neutral, incredibly important. It allows intended parents through assisted reproduction to establish their parentage swiftly through a VAP. It provides a statutory codification for de facto parentage, which makes it clear to all those who come before the court. And it allows for presumed parentage for non-marital parents as well. So I'll just sum up and say I think this is essential for the well-being of children in Rhode Island, for the efficiency of the court system, and GLAD is very much in support. Thank you so much.